Next up, we have Nikita. Am I pronouncing that correctly? Oh. Who'll be speaking on CCPA.
Awesome. Thank you so much. My name is What now? Oh, much better, right? Perfect, thank you. So similar to the European Union's General Data Protection Regulation, the California Consumer Privacy Act, or the CCPA, was enacted to provide additional privacy protections to California residents, impose additional obligations on companies collecting personal information, and also provide additional rights to California consumers. And what such right is the right to know. Under this right, California residents have the ability to request a copy of their information collected by companies conducting business in California. In order to do so, they have to submit a data subject access request, which is also known as a verifiable consumer request under the CCPA terminology. And although there are some similarities between the CCPA and the GDPR, for instance, both the CCPA and the GDPR require companies to provide back specific pieces of information upon request and also have to declare the categories of personal information in the privacy policies. There are also some notable differences. For instance, the CCPA applies only to for-profit businesses, which are also subject to additional criteria. At the same time, the GDPR applies broadly to all entities that process personal information of Europeans. Furthermore, the CCPA, under the right to know of the CCPA, the companies have to provide back the data in a format that's both usable as well as portable. And under the GDPR, those two rights are actually distinct. And so there are several reasons why the right to know is so important to consumers. First of all, the ability to request your data under this right enables other privacy rights as well, such as the right to data portability, data deletion, and data correction. At the same time, knowledge of the data collected by a company may prompt consumers to also change their privacy behaviors. For instance, they may choose not to disclose as much information moving forward, or they may adopt privacy-enhancing technologies. This is in contrast to, let's say, reading privacy policies, which often only provide high-level categorical information. Finally, the right to know allows consumers, as well as other stakeholders, regulators, and researchers, to hold companies accountable to their stated information practices, such as those declared in their privacy policies. Given this importance of the right to know, we ask the question, to what extent do Android app developers comply with its provisions under the CCPA? More specifically, we wanted to know to what extent do Android app developers, subject to the CCPA, would accurately disclose personal information in response to a verifiable consumer request that actually aligns with their collection and sharing practices, and how well that information aligns with their disclosed information practices, such as those made in the privacy policies. And before I go and talk about our methods, I would like to speak about the importance of ethical research conduct, especially when it comes to submitting requests to companies in order to evaluate the compliance with different privacy regulations. So first of all, we examined ethical issues surfaced by other works, such as Princeton Radboud study on privacy law implementation, and we also conducted our IRB office at UC Berkeley. We had two main objectives with this study in order to ensure that we conducted in a manner that's ethical and legally valid. So first of all, we wanted to ensure that we only reach out to developers that are actually subject to the CCPA. And second, we also wanted to only submit requests that are legally valid without asking any additional questions and information that was not legally provided under this right. We also want to note that this is not human subject research, and therefore it's beyond the purview of an IRB office, and the IRB at Berkeley has agreed with this assessment, and therefore they refuse to review this work. One main difficulty that we encountered in this regard was that the CCPA has threshold requirements that are not easily publicly knowable. For instance, the CCPA only applies to companies collecting personal information of at least 50,000 California residents. At the same time, we know that under the Section 5 of the FTC Act, it's prohibited or labeled as deceptive act or practice, which are prohibited under the Section 5 of the FTC Act. And such deceptive acts or practices also include material representations that are likely to mislead consumers. As such, although we initially selected 160 top-ranked Android apps across 20 different categories, we then decided to narrow down this data set to 109 apps which only contain CCPA disclosures in their privacy policies. Under the FTC Act, having those disclosures without actually complying with the CCPA would in itself constitute a material misrepresentation illegal under the FTC Act. We also analyzed each app's privacy policy in order to determine the stated information practices, as well as the third parties with whom app developers share information. Then we installed each of those 109 apps on our test devices, ran them for about 15 to 20 minutes, and collected their network traffic. So our Android instrumentation running on those test devices allows us not only to collect incoming and outgoing network traffic, but also reconstruct it and also decrypt it, even despite usage of TLS and certificate pinning. Finally, we submitted verifiable consumer requests to each 109 app developer using each app developer's prescribed procedures for submitting such requests. We also want to acknowledge that in this work, we use pseudonyms in order to submit requests and also when testing the apps. There were two reasons and two confounding variables that we tried to avoid by using pseudonyms. First of all, we wanted to ensure that the data that was prior collected about us, researchers, was separate from the data collected as part of the study. And we also wanted to avoid biasing the developers if they knew that they were part of a study. At the same time, I would like to emphasize that the CCPA actually allows for this. Under the CCPA, it defines a California consumer as a natural person who is a California resident, however identified, including by any unique identifier. Therefore, I argued that our requests were valid for two main reasons. They were only sent by researchers who were themselves California residents, and in all instances, researchers testing the apps and submitting the requests were always identifiable by a unique identifier. And finally, after we analyzed the apps, read the privacy policies, and received response to our requests, we compare all those informations to see what are the differences between the disclosed and actual data practices of app developers. So now I will go over and discuss what we learned from submitting the requests. So first of all, we found that 2/3 of app developers provided 2 or more methods to submit requests. And I have to emphasize that providing 2 methods or more is a requirement under the CCPA. And so in 65% of cases, there was an email that we used to submit, and 39% of cases, there was a dedicated portal provided by a company to send such requests. Furthermore, in majority of cases, we were asked to provide just some basic information about ourselves in order to authenticate our request, such as our names, email addresses, phone numbers. But in some cases, developers also requested technical identifiers, such as advertisement IDs or IP addresses, which might not always be easily knowable by ordinary users. And finally, only 7 app vendors explicitly requested proof of California residency. Furthermore, we learned quite a lot from the developer responses as well. So first of all, out of the 109 requests that we sent out, we received a material response only from 80 developers. In 21 cases, there was no reply. 5 companies have refused to accept our verification, and 3 companies told us that they could not verify our identity to a sufficient degree. Out of the 80 responses that were material, we received our data in 69 cases. 8 companies told us that they collected no data about us, while 3 companies told us to simply log into our accounts and get the data from our account profiles. And although almost all, that is 68 developers, provided specific pieces of personal information, only 25 named the categories of third parties to whom our information was sold or disclosed. And again, this is a requirement out of the CCPA to provide not only the specific pieces of information, but also the categories of third parties, as well as other information. And finally, we found that only 6 companies presented the same data using 2 different formats for usability and portability purposes. In the remaining cases, we received data that was either only human readable or only portable and machine readable. And again, this is a requirement under the CCPA in order to get the data back in a format that's both usable as well as machine readable. And finally, we analyzed the responses, and this is what we found out. So although 8 developers claim not to collect any personal information, we found that only 1 appeared to not actually do so. In the remaining cases, we found that developers would collect at least some information that they would not disclose back to us. Finally, out of the 68 developers who provided specific pieces of personal information, we found that only 9 fully disclosed of their data collection practices. When it comes to privacy policies, we found that 31% did not fully disclose the collection of personal information, while 21% did not fully disclose the sharing of information with third parties. And to summarize our results in terms of compliance with the CCPA, well, we found that out of the 109 companies that we investigated, 34 did not provide multiple means to submit requests, 24 did not respond to a request at all. And then out of the companies who actually responded back to our data, we found that 91 of them did not provide data in a usable and a portable format, 87 did not fully disclose the personal information collected about us, and 64, for instance, did not provide the categories of third parties, among other things. And I would like to finish my presentation with a series of recommendations. You can find more information about this in the paper as well. For developers, we want to stress that, if possible, they should use existing authentication mechanisms to confirm the identity of the requester, and they should ensure secure access to and transmission of consumers' personal information. So, for instance, they might use 2-factor authentication when that's possible, links with expiration dates, and other measures. And finally, they should also provide information in several formats that is both human readable and portable. And for regulators, we want to stress the importance on educating developers on what actually constitutes personal information and to provide more guidance on the contents and the format of VCR responses. Thank you so much for your attention. I will now take questions, and my contact information is here.
Thank you. First question, did you just run the apps on their start screen, or did you engage with the user interface either manually or using UI automation?
So we manually engage with the apps. We try to cover as much of UI as possible, but because of the different categories to which the apps belong, there was not like a single procedure. We just tried to cover as much of a UI interface as possible.
Okay. Next question, did it appear that all the responses were generated manually?
No, so there was kind of like a difference between, I guess, some level of automation involved in some of the responses. In particular, some of the companies provide an interface where you could log in and request your data yourself. So that seemed to be, and sometimes the data would be provided back immediately. So that seemed to be provided automatically. In other cases, there was also a level of manual compilation of the data that we received after some time from the developers.
How manual or automated were your processes for privacy policy analysis, submission of the VCRs, and then checking of the consistency of the practices versus the statements? And what tools did you use for automating these tasks, if any?
Well, most of it was manual, so we had people read privacy policies and actually annotate them and have like multiple researchers do qualitative coding of them. We submitted the requests manually as well. I guess in terms of automation, mainly was the correlation of data that we found from app testing and from the other sources. But all of the interaction with privacy policies and developers were manual.
Could you please expand on the non-responses due to could not verify? Were there additional authentication checks that were performed that you weren't able to complete due to your use of pseudo-identities?
Right. So there was 8 cases where developers told us that they could not verify. In 3 cases, the problem was more that they told us there was not enough information collected in the first place and they were not able to provide back a response. In 5 cases, the developers basically refused to accept our identity documents because they tried to get us to provide even more intrusive information, and at some point we just couldn't really do that. So basically that's it.
Okay, I think we have time for one more. How did you determine if any app vendors had fully provided all the information they'd collected about users?
Well, we did the app testing of apps, so we actually observed the traffic that's being we first observed the data being collected on the platform, but we also observed what information was sent where, and so that was kind of our set of the ground truth that we compared against the responses in VCR.
Thanks again. There are a bunch of additional questions, but we're a minute over, so feel free during the break to ask those.